Hi, I'm Len Witt, and I'm here with David Schmidt. He's the National Chair for the Coalition for Juvenile Justice, and we're in Washington, D.C. for their spring annual conference in 2011. So, David, I've been told that you are pretty passionate about trying to reduce long sentences given to juveniles. Can you talk a little bit about what the state of all of that is right now and how it could be changed?
Yes, I've been very concerned about the juvenile LWOP since I was chair of the Federal Advisory.
The juvenile what?
Juvenile LWOP. I used to think it was leave without pay, but soon learned that it was life without parole.
Okay.
It's a sentence, it's a lifetime sentence given to somebody who commits a violent felony. It used to be inclusive of anything from armed robbery to murder. The Supreme Court ruled on it during this last session and eliminated life without parole to those offenses that don't include murder. So it now applies only to murder.
Was it you, or it was said the other day, or was it another speaker, I can't remember, who said, yeah, but a judge could say, all right, I'm going to give you 150 years, I won't give you life without parole, I'll give you 150 years without parole. They can do that, actually?
That's correct. There's already been a case in California because they have to resentence those that didn't commit murder. And that young man was sentenced to 110 years. So the fear that I was expressing has now come to happen. I think in order to develop a remedy for it, we have got to be very active in developing legislation and passing legislation on a state as well as a national basis that demands that anybody who is sentenced for a crime committed when they are under 18, I would prefer that it was 21, have a mandatory review.
You know, but I guess my question would be with a lot of citizens, and I think these things came around, all right, so you treat the kids without hard penalties, and they're going to go and kill people or rob people and think, hey, they can't put me away for a long time.
Well, they do put them away for a long time, and even if they were sentenced and you had a review, there would be a review of the readiness for release. I'm not saying that there are not dangerous young people, because there are, and they should be sentenced in a manner which protects society, because it is a public protection issue. But also you have to consider the individual that is doing it. Most of our young people are sentenced because they are waived to adult court, they are sentenced without an amenability hearing or all of the psychological and social factors being considered by the judge. That should never happen. Given that if those factors were considered, then a judge would be able to tailor the sentence appropriately to the individual. I come from New Mexico where I helped design a code where a child can be sentenced to a juvenile facility to the age of 21. We had a situation, as an example, where a young man killed his stepfather, killed his mother, and killed his sister. He was tried in juvenile court, and all children in New Mexico are tried in juvenile court, except for first-degree murder. The judge, after hearing all of the amenability factors, found him guilty, but sentenced him to the juvenile facility rather than the adult facility. He remained there from age 15 to 21 and has become a productive citizen.
So, but let me just get this straight, because people are going to say, didn't you just say he murdered 3 people and then he got out of jail in 6 years?
It was his family, and as it turned out, he was severely abused and cracked. He broke.
Okay.
under the abuse and murdered them.
Okay.
But the essence of it is that he had an opportunity to appear before a children's court judge who is trained to listen to all of the amenability factors rather than just the crime itself and then oppose a sentence. Most judges are not able to have the opportunity to hear all of the factors involved.
So how does the public react to that?
The public reacted very well, surprisingly. That judge has received national awards because of the courage that he exercised in that particular case. But getting back to the juvenile LWOP,
Okay.
I consider that a death sentence because a child is put in a situation where they have no hope, where they have no hope of release. Psychologically, it is damning and damaging to them. They will not face the possibility of parole. So and the reason I refer to it as a death penalty is that the death of the individual is determined by God instead of by a jury that is saying you should die. His death is determined by God rather than a standard death penalty where a fixed date is determined by a jury. So either way, it's a death penalty if you're there until you die or don't have the possibility of release.
So how many kids now are sort of in jail for their whole life or pretty close to their whole life?
Approximately 2,500.
2,500 across the
Yes.
country. So that's like 50 per state on average or something like that.
Well, no, only 27 states use juvenile life without parole.
Interesting. So it's geography.
It is geography.
Interesting. And which state has the most of those kids?
I believe it is California.
Interesting. Do you want to add anything else about that? Is there a way of fixing it for those 27 states? Should it be fixed?
It absolutely needs to be fixed. Every one of those cases should be reviewed, and the child should have an opportunity for periodic review. Juvenile LWOP has to be repealed in all states. If states don't repeal it, they can give them life, but they have to give them an opportunity to be reviewed for release.
Are lawmakers buying into this argument or not?
It's too soon to know.
Okay.
The second remedy is I think the Supreme Court was cowardly in not addressing the full issue of life without parole for all individuals and stopping only halfway in their decision making to say that those that have committed murder.
Why would you call it cowardly? Pretty strong statement.
It is a strong term because they should have addressed the same issue and applied the same circumstances to those that committed murder as they applied to those that committed less than murder. Brain development, how sophisticated was the child involved in a trauma situation, what were the psychological factors that led them to act out and do what they did. And that's why I gave that example of the 3 murders.
Okay. So we talked about legislators. What's sort of the going opinion among judges and prosecutors? Because they're the ones who have a lot of power and discretion.
Judges have a lot of power. So prosecutors, there are many states where the prosecutor makes the decision on what they're going to file, what charge they're going to file, and what sentence they're going to go after. And that's prosecutorial decision making. There are some states that have statutory, where it's a mandatory sentence on a given crime, and the punishment that is allotted to that crime. Then there is the third state, and there are very few of them. New Mexico happens to be one of them, where the decision-making is left up to the judge who has the most facts available to them.
So in those 27 states, were there at one time 28 or 29 states, have any changed and have some evidence that it was a good idea to change?
I'm not certain which, at this point, which ones are contemplating change. None of them have changed statutorily, but again, I iterate that the Supreme Court decision just came down. It's less than 6 months old.
Okay. Well, thank you very much. This is very informative.
Thank you.